because Judge Doolin's already made that determination. So you got to get around that.
I'm happy to, Your Honor. The difference with Shaquille Brown and Judge Doolin's decision and why it matters here is context is everything in terms of his intent.
And if you've read the grand jury transcripts, you know, they did ask questions, and they certainly could have said, you know, you're only showing us a snippet here. We'd like to see the whole video. Nobody did that.
The court should factor that in. Now, how can the court make a finding whether this was intentional or not without hearing from Mello, Tully, Peter, anyone else who may or may not be involved in this?
How does this affect the grand jury presentation?
And that's Mr. Kearney's intent. That's the only issue that was really before the grand jury. And none of that was seen in Judge Doolin's opinion because none of that was before.
Because it wasn't raised.
Well, it wasn't raised, but it wasn't known by anyone. Now, again, could it have been? Yes, but the court has the discretion.
But it was known because Judge Doolin referred to it by the titles that you think are inflammatory.
Question from Mello to Tully. Before he plays all of these videos, which are misnamed, cherry-picked, do you have any knowledge of incidents which you feel are intimidating of a witness with respect to any particular witness? I do. Question, those are on video. Answer, they are. There is a strong argument that could be put forth if there were to be a trial in this case that this investigation was biased, it was shoddy, and that involves any number of things, one of which includes, from our perspective, which is a shockingly close relationship between a private civilian, Peter, who you mentioned, who has a hatred of Mr. Kearney that is beyond adjectives that I could even provide this court with. Mr. Mello took another shot at a grand jury involving Mr. Kearney and Karen Reed for essentially...
But not this grand jury.
No, but...
All right, then we don't need to go there.
Your Honor, if I can have 10 seconds of leeway, none of the misconduct occurred in that grand jury. And what happened? The same allegations, same type of evidence, and that case was no build.
That's a whole different ball of wax.
Judge, I'm not talking about anything other than it was the same video evidence and Tully talking about the same things. And admittedly,
I'm going to guess there was a whole lot more to that grand jury than these videos.
Not much.
Whatever. It's not what I'm not before.
Understood.
Me. I'm not reviewing it. I don't have access to it, so I can't draw a conclusion as to whether or not it affects how it compares. But let's deal with the motion to dismiss first. Mr. Bedero, your motion, I'll hear you.
Thank you.
You might want to concentrate on a couple of things to start with. Number one, there was already a fully litigated motion to dismiss both under McCarthy and under Odell, in which Judge Doolin drafted a 36 or 37-page decision, which is an exceptionally fulsome decision from the court, in which he found probable cause for the majority of the indictments, but dismissed all of them, including the one that seems to be at the heart of a number of these motions, that is to say, against Mr. Proctor. So the first issue is this. Under Rule 13 and under Commonwealth versus De Los Santos, which I'm sure you've reviewed, which is 492 Mass 242, 2023 case, if the matter was not raised, it's considered waived. So tell me why. I understand the issues with Ms. Peters may have been disclosed post that hearing, at least to some extent. Tell me why the other issues aren't waived under De Los Santos and Rule 13.
Okay. Was there another issue, Your Honor, you wanted me to focus on?
No, that's to start. Then we'll get to the substance of it.
Thank you, Your Honor. Judge, it is true that many of these issues existed in a grand jury transcript and motions that were ruled upon by Judge Doolin. That is correct. And Rule 13 does state what it states, but there is case law which also states that the court does have the power to reconsider or reevaluate issues which were not brought to the court's attention. Now, in this particular case, there's no question that issues that related to the wiretapping, the uncharged wiretapping, for example, could have been raised. As the issues related to some of the videos in this case, the name changes, the court should be aware that for whatever reason, that snuck by everybody, including Judge Doolin, including Mr. Cosgrove and some of his filings. And as soon as that was picked up, that is something that we put into writing and addressed right away. The reality is the grand jury in this case was not proper. I mean, I think, and I'll get to that in a minute after answering Your Honor's question about the waiver issue, but in terms of the form over substance.
Well, it's not really form over substance. It's substantive. Rule 13 is substantive. Dello Santo is substantive. And there's a reason for that. And the Commonwealth in their opposition has pointed it out. It's because you can't keep retilling the same ground over and over and over. At some point, you got to move forward. So it's not just form over substance. So you got to give me a little bit more than that.
Well, Haskell permits it, Judge.
It does at the court's discretion.
Right.
But you got to have a reason.
Absolutely, there is discretion of the court to ultimately decide what should be done and what shouldn't. But where the court sees prejudice, the court respectfully should act. Now, again, with the videos that were mislabeled, the Commonwealth shouldn't benefit from what is clearly deceptive conduct in terms of renaming items that, again, nobody saw. Judge Doolin himself referred to the names by their improper name during his ruling.
Which presumes that Judge Doolin was aware of those names and didn't find them to be of any substance because he watched the actual videos.
I don't know. Well, the actual videos that were presented to the grand jury, Your Honor, were 40-second snippets of hours-long video, which were not grand jury exhibits. So respectfully, there's no way that Judge Doolin could have watched those videos because Mr. Mello...
Well, he watched the clips, no doubt.
Yes, but the clips are tiny segments of larger videos that, again, when we get to the real meat of what I want to discuss with the court, would show the full context on the critical issue in this case, which is only one, and that's Mr. Kearney's intent. That's the only issue that was really before the grand jury, and none of that was seen in Judge Doolin's opinion because none of that was before.
Because it wasn't raised.
Well, it wasn't raised, but it wasn't known by anyone. Now, again, could it have been? Yes, but the court has the discretion.
But it was known because Judge Doolin referred to it by the titles that you think are inflammatory.
Yes, those are the names that he was provided by the Commonwealth that were changed. Those were the improper names. Names that the Commonwealth knew in advance were not the proper names and were changed. And ultimately, Your Honor, as a matter of discretion, there's no prejudice to the Commonwealth here by having this. I suspect this argument, which is a fair argument to make, is their primary argument because they don't want to talk about what actually occurred in the grand jury. And the fact of the matter is everybody sees it, everybody knows what it is, and it ought to be addressed. If there's no prejudice to the Commonwealth, the court should hear it. No indictment should be tolerated when it is rife with misleading evidence, distorted evidence, statements of prosecutors and police witnesses saying, in my opinion, it was this man's intent to commit witness intimidation. That's outrageous behavior in front of a grand jury. And when you get down to brass tacks in this case, that's all that this is about. They misled the grand jury on the only issue that matters, which is whether Mr. Kearney's intent was to commit witness intimidation or not. The conduct at issue is open and shut. It's the videos, not the videos that were submitted into the grand jury. Those are tiny snippets. The conduct and the context of Mr. Kearney's intent are contained in the actual videos. And what you have at this point, it's very similar to Odell itself. In essence, you have prosecutors cherry picking 30 seconds they like out of a 2-hour video and saying this proves his intent was to intimidate witnesses, but not letting the grand jury have access to the other 2 hours, which show him saying, I want to bring awareness to a miscarriage of justice involving Karen Reed. I'm petitioning the government to address that. I believe that these police officers are corrupt. We're doing this to bring justice for these people. The grand jury had a right to that. And the best example of this, Your Honor, to get a full picture of what you're dealing with is all of the picketing counts in this case are from this so-called rolling rally. That entire video, the whole rally was recorded, video recorded by Mr. Kearney, literally the crime, if you will. They didn't introduce that video, but what they did do was admit 58 seconds of the rolling rally, which the honest name of that video on YouTube was Canton, the rolling rally Justice for Karen Reed and John O'Keefe. They took 58 seconds of that video. They introduced it as the title of that video is Don't Feel Sorry for the O'Keefes. That's not evidence, but if you look at the grand jury testimony and the transcript, the way Mello and Tully did this is Tully said, the name of the video is Don't Feel Sorry for the O'Keefes. It's contained in a folder literally titled Intent, literally. And he did that approximately 30 times throughout this proceeding, told the grand jury, this is proof of his intent. They literally asked questions and answers that talked about intent. They played 30 to 50 seconds of this video where he literally says, don't feel bad for the O'Keefes, but yet don't present the video of the crime. Why, what prosecutor?
But their allegation is that is the crime.
Your Honor, again, it goes to Odell, literally. They can believe anything they want. They can allege anything they want.
But they're not alleging that the rest of the rally was intimidation. They're alleging those clips are the intimidation.
Right. But, Your Honor, when they present it to the grand jury, it's tantamount to what happened in Odell with the police report, where we decide we like sentence 1 because we think it proves his intent, but we don't like sentences 2, 3, 4, and 5. So we're just going to keep that from the grand jury. In Odell, that was deemed to have impaired the integrity of.
But a police report and a video are very different things. We often encounter situations at the grand jury where they have hours and hours of videotape, but they only play certain clips. But
they didn't tell the grand jury it's available for you. The point is they told the grand jury the name of the video is jury influence is another one, which was actually titled Protesting Michael Morrissey. Big difference. A video that was 5 days after DA Morrissey made a statement to the press, which was improper. He gives a 2-hour video and says, I'm trying to bring awareness, trying to do this and do that. And this is in August of 2023, well before trial. And says, absolutely, I want to influence the public and the jury pool. And they take that little snippet. They may have a theory that enables them to say, we believe that's proof of his intent. That's fine. What's not permissible, though, is to rig it in the following way, to say, literally, Your Honor, I can read to you there's a literal question and answer, which is very important. For example, on December 19th, question from Mello to Tully before he plays all of these videos, which are misnamed, cherry-picked. Do you have any knowledge of incidents which you feel are intimidating of a witness with respect to any particular witness? I do. Question, those are on video. Answer, they are. Play those for the grand jury. So now we've just told the grand jury, I think his intent was to intimidate witnesses. Then what Tully does again and again through direct intentional questioning of Mello, it's not volunteered, is to say that these videos are named inaccurately, and they're in the memo. You've seen them, page 62 and 63 of the motion, all the times that they did this. They play the snippet, and then when it's over, they tell, or before they do it, they tell the grand jury, these are from a folder marked intent. He didn't do that.
Yeah, but slow down, Mr. Pedro. You have to give the grand jury some credit. The grand jury understands that a defendant is not going to create a folder which says intent. They had to know the prosecution created it. That's
my point.
Right, but give the grand jury some credit. They understand that.
Your Honor, the point is, respectfully, when a police officer tells the grand jury, in my opinion, this man's intent was this. I have a folder with proof of his intent. It came from that folder. I'm going to tell you a false name of the video that I renamed or some third party working with him renamed, whichever the case may be. And then you don't tell the grand jury that this was renamed by us, put in this folder by us. I'm playing you 30 seconds, but I'm not going to give you the rest of the video. And I would refer the court, this case is cited in the memo of law that went with the motion, Bleakney, the appeals court case, not the SJC, the lower appeals court, where they cherry-picked a portion of a statement of a defendant, left the full flash drive in front of the grand jury, but never alerted them to the contents of it. And in that case, the appeals court found it impaired the integrity by hiding the ball. Here,
if you're going to go there, Mr. Better, if you're going to go there, then you got to talk to me about Shaquille Brown, which is the SJC, in which the prosecutor dumped in at least 100 pages of prison records, in which the prosecutor dropped in telephone logs, all of which had never been looked at or never been read. And the SJC said, well, it wasn't so good, but that's okay because it didn't change the analysis of the evidence, which takes us back. And this is the
yes, sir.
Slow down. This is the difficulty that you have. So this is why De Los Santos does matter, and it is substantive. Okay, this is why Rule 13 is substantive, because you already had a very thoughtful, all right, a bulwark, if you will, from a judge. All right, a very thoughtful judge who examined in detail the entirety of the grand jury, found it to be free from prejudice, and more importantly, found that the evidence was substantial enough to issue an indictment. So that brings us back to the court's analysis in Shaquille Brown, which I'll give you the site if you like.
I have
490, 171, and I'm very familiar with that case. All right. In that case, the court finds clearly they shouldn't have done any of those things, but finds it didn't impair the integrity of the grand jury, and this is why De Los Santos is substantive, because Judge Doolin's already made that determination. So you got to get around that.
I'm happy to, Your Honor. The difference with Shaquille Brown and Judge Doolin's decision and why it matters here is context is everything in terms of his intent. Oh, he is
but in Brown, they're trying to show joint venture, and they dump in prison records they haven't even read.
Judge, I'm bringing it to this case, okay?
Yeah, but this is the SJC telling you this.
I understand that, but the facts here matter, and the context matters, and just because the prosecution has, a one-sentence explanation of what they say and a grand jury ultimately determined was proof of intent after they were told what his intent was by the prosecutor, by all the reasons that we spoke about earlier, context is everything. If there is a long statement that is talking about protesting and bringing awareness and making jokes and all kinds of things, and there's a comment in there that I like that comment, just give the grand jury the whole thing. The role of the grand jury is fact finder. The problem in this case is that Mello and Tully decided to be prosecutor, detective, fact finder.
Grand jury is not really fact finder. Grand jury is more of a gatekeeper. But go on.
But they have to, Judge, respectfully, they're not. They have to find the facts to support an indictment. And in this case, they literally did, but they were misled. And context matters. A grand jury is entitled not to everything in the world. It's clearly not a trial jury. We all understand that. But when you do it, you have to do it fairly. And they put their finger on the scales with evidence of his intent in terms of what they told the grand jury, what file it was in, the length of the video, the full context of the video, the uncharged crimes. Judge, the last piece of evidence in this case that they put in the grand jury was an uncharged crime of, again, the rolling rally video, which they didn't see fit to give the grand jury, which makes no sense. If anyone's prosecuted these cases and put in cases in a grand jury, that makes no sense. That's the crime. Give it to them. But what they did was they tried to suggest that he was harassing and intimidating the O'Keefes, who were not even charged victims in this case. That's how they finished the grand jury. That is clearly a design to prejudice, to smear. They put in evidence of an uncharged wiretapping and read the statute that said this is punishable by 5 years and never gave a curative instruction, never withdrew that charge. De Los Santos or not, Your Honor, the question is, at what point do we not avert our eyes to what they did? They need to do it fairly.
But a judge has already looked at that.
But he didn't see that, Judge. If you look at Judge Doolin's decision, none of that is addressed because he, like everyone else, was misled. Moreover, Judge, I am focused on the grand jury. I'm going to answer the questions that obviously you're focused on. There was a second component to the motion for extreme government misconduct, and there's no reason why. Well,
I'll listen to you on the Peters stuff. I mean, I think if Peters wasn't known to you, I think that's fair to discuss.
Well, it wasn't. I mean, the whole point. But before I get to the merits of that motion would have been made anyway. So that, I mean, because we can't make a motion based on evidence of which we're unaware, obviously. And at that point, if you're making a motion to dismiss for extreme government misconduct, there's no reason why the court should not consider as a facet of the misconduct that occurred in this case what occurred in the grand jury before. Now, as far as the Peter stuff, which I don't want to beat to death, and most of it is in the papers, the point is all of that evidence should have been disclosed in early 2024, which was we're closing the deadline for discovery. That material didn't come anywhere near that timeline. It came in July of 2025 after numerous specific, very specific Brady demands and Discovery Rule 14 demands. They could not have been more specific.
So let me understand, what is the basis that you're asking me to dismiss? Is it for the discovery violations or for the substantive violations?
Well, it's for everything. On the second component of the motion, the indictments ought to be dismissed based on the impairment of the integrity of the grand jury proceeding, full stop. As far as the second component, based upon the lack of discovery, that prejudiced us from filing a full-throated motion the first time, and the court should consider that in even hearing the grand jury component of it. But in any event, if the court is wondering why, if discovery was ordered to be completed in early 2024 and all these demands were made before, during, and after that time period, and stuff that is responsive is showing up in July of 2025 that we turn out to learn was in the possession of every single prosecutor on these cases in December of 2024, which is before the motion was filed in front of Judge Doolin. What is going on?
I consider these to be two separate categories. That's why I started with the issue of Peters may be something which is outside the Rule 13 and the De Los Santos analysis. So I'll give you I'm giving you an open field to discuss that.
Okay. Excuse me, Judge. The evidence that exists or no longer exists from the third party that the court mentioned is extremely prejudicial to the defense. There is a strong argument that could be put forth if there were to be a trial in this case that this investigation was biased, it was shoddy, and that involves any number of things, one of which includes, from our perspective, which is a shockingly close relationship between a private civilian, Peter, who you mentioned, who has a hatred of Mr. Kearney that is beyond adjectives that I could even provide this court with. Not only that, this is a witness who has falsified evidence against him. Literally, this is not in dispute. It's in the motion. Has forged court filings to try to screw him in part of their fighting during their life. Has attacked witnesses for the Commonwealth, Alberts, and tried to get him to say bad things about them when she, in fact, defamed them. And this person was basically holding Mr. Mello's hand. These are the messages that we got, amongst other things, telling him what to do. And when we got that affidavit from Tully, oh, well, I didn't open or click on any of these links. That's a problem for one reason, because they were in their possession, custody, and control. It ought to have been turned over. And what was contained, we don't know. But there has to be under Neal a reasonable basis to believe there might be something useful. And the reasonable basis you have is that the person who provided it to Tully that he claims he never opened has committed forgery, fraud, deception, and crimes against him. She's a dishonest person who is working hand in hand with the prosecutors in this case. Now, Tully says, I never opened it, and now the links are gone. And we were told in filings, it's been dismissed, it's been deleted by a third party, which presumably is Peter. And what are we supposed to do in now finding the evidence to support that defense? Just assume it's nothing helpful? Why would we assume that when this woman is bent on destroying him and
commits fraud? Isn't the shoddy work that he never opened them?
What's that?
Isn't the shoddy work that he never opened them?
That's amongst other things. But I had said to you, Tully said that. That's not what Mello did. The emails that we got too late in the process literally show Mello and Peter talking, and he's asking her help. How do I open this? And Mello says, gee, thanks. He literally opened it. Opened what? Where is it? Tully says, I never opened it. It's deleted. Mello, very noticeably, never submitted in all the time the prosecution had to respond to the motion. And if the court remembers, they got many graces in deadline extensions to file, never submitted a sworn statement explaining any of this. What we got instead was a hearsay statement where Mr. Cosgrove, and I say this with due respect to Mr. Cosgrove, was essentially cosplaying as Mello, saying, this is what it would be. That's not evidence in response. What was required is something from Mello under oath, and we've never gotten that. And that's very important too, Your Honor. One of the things that we asked for in the motion is, as an alternative, a hearing, okay? If this was intentional, the court should factor that in. Now, how can the court make a finding whether this was intentional or not without hearing from Mello, Tully, Peter, anyone else who may or may not be involved in this?
How does this affect the grand jury presentation?
Well, Peter,
I just want to see the argument. I'm not...
As far as the grand jury goes, it's either Tully or Peter who renamed these files. Now, Tully knew the full name of the files.
But according to Tully, he doesn't open it. So I'm just trying to... you may have a separate argument. I'm not saying you don't. Okay, as to what the relation between Mello and Peter was or was not. I'm just trying to make sure I understand your argument. Is this part of the Odell, or is this some separate motion?
Well, on some level, it's a hybrid. I mean, there's clearly the Odell component.
But I got to understand what that hybrid is,
right,
counsel. You give me kind of a mishmash here with all sorts of stuff in it, and I'm trying to sort it out.
Judge, there's a standalone Odell motion, clearly, about impairing the integrity of the grand jury proceeding. We also filed...
But how does... Go on, I'm listening.
There is a second motion to dismiss for extreme and egregious government misconduct based upon... beats me a separate motion to dismiss based on what you filed, Mr. Betteroff. No, Judge, it's a second point.
All right, this is the problem with what you filed, but we've discussed that already. I can't discern that there's a second motion to dismiss. It looks like a big Odell.
Judge, we don't know what missing evidence we didn't get. And the argument that was put forth in Mr. Cosgrove's response to this was that if you don't know, then there's no obligation for us to turn it over because there's no reasonable possibility to conclude that it would be favorable to you. And the point is, when it's evidence that was deleted, that was reviewed by Mello, Tully claims he didn't, and it comes from a source who hates him and commits acts of fraud and forgery against him, there's a reasonable basis to believe that something wasn't right in that evidence. We don't know. And this woman was assisting these people back right before literally days before the grand jury, explaining to Mello how to use the evidence. What is that evidence? She sent a folder titled intent. That may very, we don't know, but that may very well be the clips, the change names. She'll probably deny it. She'll go online and deny it and scream and yell about it. Tully says, I never looked at it. Mello is unheard of. He's just disappeared in the wind. There's no sworn statement from him. These people at a minimum should be called in, take oaths, and let's get to the bottom of it.
Well, I'm going to need a better motion than what I got in order to do that. But Mr. Cosgrove, what do you got to tell me?
Just go through it.
Where you think is important.
Okay. First, whenever I hear counsel use the word cherry-picked, what that means to me is the Commonwealth picked relevant evidence to support the charges it was looking for. I don't have any real answer. I don't deny that that was what, in this case, Mr. Kearney said and did and put on the air.
Well, why not give them the whole video?
I'm sorry?
Why not give them the whole video? To go to Mr. Bettero's point, why not give them the whole video to watch and play them selected clips as is often the case?
I don't know what the reasoning was at the time, Your Honor. If you look at the chart that Mr. Bettero includes in his motion, or his affidavit rather, it runs on for about 3 pages. There's lots of videos. They tend to go about 2.5 hours each. If we give them the whole video, there is lots of other material in there that language used by Mr. Kearney, whatever. It could be construed as prejudicial. I'm sure Your Honor has already heard about reference to the O'Keefes. And the Commonwealth introduced this, and they didn't indict him with respect to intimidation of the O'Keefes, and this was entirely inappropriate, et cetera, et cetera. I'm sure if Mr. Mello had put in 25 whole videos, we'd be getting an argument that all kinds of prejudicial material was put in, and that the Commonwealth should have simply chosen what was relevant to the indictments. I have to say, where's the beef? I keep hearing about stuff being taken out of context, and if only there was the context, if only the whole thing had been shown. Defense has read my response and said, Your Honor, and one of the things I said was, where is it? Where's the submission to the court? These are the things that if only the grand jury had viewed them as Your Honor is now capable of viewing them because we have submitted them, and certainly Mr. Kearney has access to his own video, it would have put things in a completely different light, and here's why. You don't have any of that. There may be some things in the entire videos that, for example, Mr. Bettero says, at one point, Mr. Kearney talks about how he's going to expose corruption or something like that. Or Mr. Kearney could have 16 different motives. People have more than one reason for doing things, for putting something in. Some of those motives may be good motives, but those motives are irrelevant. All the Commonwealth has to prove is that one of his motives was to intimidate those witnesses. That's what's relevant. Furthermore, I think, as Your Honor alluded to, we can infer a certain degree of sophistication on the part of the grand jury. Nobody watches even the evening news and sees a snippet of a Trump press conference or something going on in the city of Boston or an excerpt from what's going on in court and leaves under the delusion that other things weren't said, other things weren't happening. They understand that the news media selected what they considered relevant and showed that. In fact, I think that's what Mr. Kearney does on his own broadcasts. People are sophisticated based on years of watching news shows and years of, at this point, watching the internet. There's nothing to stop a member of the grand jury, and for each of these witnesses, grand jurors had an opportunity to ask questions, and if you've read the grand jury transcripts, you know they did ask questions, and they certainly could have said, you know, you're only showing us a snippet here, we'd like to see the whole video. Nobody did that.
Are we going to put this on the grand jury to make sure that they get a square presentation?
No, I don't think we're putting it on the grand jury. I'm simply pointing out that in addition to the other points I've made, the opportunity was there. Nothing was being concealed. I think the practicalities of presenting the grand jury with however many hours it would have been, 26, 46, however, these shows of Mr. Kearney's run about 2.5 hours, would be somewhat absurd, frankly. I think the Commonwealth's obligation was to show what was relevant, and that was what we did.
Okay. Tell me about the issue, your thoughts on the issue with Ms. Peters and Mr. Mello.
All right. With respect to Ms. Peters, I want to make a couple of points. One is Mr. Federer raises this issue of the prior federal court suit, which Ms. Peters apparently admitted to having forged a document or something of that nature. Well, Mr. Kearney would be aware of that because he was involved in it. But there is no reason why the best of prosecutors, when somebody comes to them with information, they may check out the information, which is what was done here. People went and looked at the broadcasts that they were pointed to, why they would go back and screen for federal court cases to see if the witness had previously been involved in a federal court case. I don't know. It's not a search warrant where you're trying to establish the veracity of the informant, and maybe you do some research in that case, although I think it would be rare that that kind of research would be done. So the suggestion that the Commonwealth knew or should have known that this witness was tainted in that respect, I think is somewhat absurd.
To the best of your knowledge, were any of the Peters materials presented to the grand jury?
The Peters materials were presented to the grand jury in the sense that there were a couple of audio recordings that were obtained from Kate Peters, which Lieutenant Tully could not find checking independently, because the theory was that Mr. Kearney had taken them down and had replaced them with different videos in which he had intercut a warning that was not actually there originally, that the conversations were being recorded. One of those...
This went to the wiretap indictment, which didn't happen.
Right. So those are the only two. The rest of them, whatever was brought to Lieutenant Tully's attention, and I can't tell you the extent to which they were brought to attention by Kate Peters, or the extent to which they were brought to attention by the victims in this case, who were obviously not happy with some of Mr. Kearney's broadcasts about them, or by both. But in every single case, Mr. Tully's representation is that he himself went to the internet, looked up the broadcast, recorded it himself, or caused it to be recorded by somebody in the office. I have to say this predates me, but I have no reason to doubt that representation, and presented them to the grand jury. And I would point out to Your Honor, to this moment, there has been no representation that any portion of the videos that the Commonwealth showed, which we presented to the grand jury as things that Mr. Kearney himself had recorded and broadcast, were not genuine. There's only been this argument that, well, they were taken out of context. If they saw something else, the jury might have thought something different.
Was the grand jury, I should maybe know this, were the wiretap indictments no-billed, or were they withdrawn?
We didn't proceed, well,
Or did they not ask for a vote, actually, is a better way to put it.
Well, on the Gaetani wiretap indictments, those were issued, but that complaint was...
Yeah, I'm not worried about that.
So that leaves us with the Scanlon presentation. And what happened was, after the presentation was made, an issue was raised in the mind of an issue was raised with the prosecutor as to whether, in fact, a Norfolk County grand jury would have jurisdiction. Mr. Scanlon having been, I believe, in Suffolk County for his end of the conversation, and I believe Mr. Kearney was not in Norfolk County at the time either. So there was some thought that maybe, as I understand it, maybe that Mr. Mello would ask Mr. Morrissey to get himself appointed as a special prosecutor for Suffolk County for the purpose of seeking an indictment there and joining it, but it was never pursued. You know, with that in mind, the Norfolk County grand jury just expired without anything further being done. So nobody ever went in front of the grand jury and said, this is withdrawn, but at the same time, no true bill was proposed to the grand jury relative to Mr. Scanlon.
You just never asked for a vote on it.
Never asked for a vote.
Any more you want to tell me?
No, I'm content to rest on my memorandum unless Your Honor has questions.
Mr. Betterow, I want to go back to this Peters thing, because I'm struggling to understand exactly what your basis on the Peters evidence is. It is a loss of exculpatory evidence? Is it, I don't know, you tell me, because again, the motion comes in as an Odell McCarthy sort of, and then goes on for many, many paragraphs, but never really tells me much about why this is important. So is it an Odell, or is it a Commonwealth versus Willie loss of exculpatory evidence? I gotta know.
We don't know what Peter evidence ended up before the grand jury because nobody seems to have it. What I can tell the court is she provided a copy of a Scanlon alleged illegally wiretap call.
Which isn't part of this indictment.
No, but to get to the point where they just said on the Scanlon evidence, we just never asked for a vote. What they never did is what every prosecutor should have done, which is instruct the grand jury, disregard that. They didn't do that. I mean, that kind of just slipped by in that exchange that was just had. You put forth uncharged crimes of wiretapping and actually tell the grand jury this is punishable by up to 5 years in prison for whatever reason. It doesn't matter. You choose because you think there's no jurisdiction or not. What Mello was obligated to do as the legal advisor to the grand jury with a duty of fair dealing, not to be an advocate, but a fair and honest broker, was to tell the grand jury, you must not consider any of that. You should not consider that evidence. You should not consider any possible penalty. So where did that come from her? We don't know. We also know that she sent evidence to Tully and I believe also Mello saying, I have taken clips from videos which show his intent in a folder named intent. We don't know where that came from.
Let me try to separate this out because I'm trying to understand your argument and be very fair to you, okay? It doesn't sound like there's any argument here there's a loss of exculpatory evidence.
Correct.
All right, so we can take that off the table, right?
Yes.
Is that a yes or a no?
Yes.
All right, so I don't need to worry about that. So what I'm now left with is the argument that the information, the only information that we seem to have right now with regard to Peters is the Scanlon non-indictment, right? Does that seem about right?
And sending clips from videos in some folder named intent to Tully. That as well.
But we don't know that any of that got in front of a grand jury.
We do not know if that's literally what he used. Correct.
Right. So what we do know is that the Scanlon information got to the grand jury.
We believe so. I mean, I can't tell you if they took her version and found it.
But we know there was testimony about that or evidence about that.
There was testimony of that uncharged crime that was left there.
I'm really trying to hone down your argument to something I can get my hands around. All right. Now what we're left with is the question of whether or not the grand jury was under Brown tainted by the inclusion of that evidence. It's a high standard, really difficult, given Judge Doolin's findings already. Or whether or not Mello had an obligation to instruct the jury on the law about that now withdrawn or not pursued indictment. Is that summarize the argument?
It does. And Your Honor, I can't fathom a world in which a prosecutor...
I'm just trying to make sure I understand the argument. I don't need further argument on it. I'm just trying to figure out if that's the argument.
Of course, he should have instructed the grand jury to disregard prejudicial uncharged crimes, which could result in somebody going to prison. Yes.
But I still have to go back to the Brown issue of whether or not it affected the integrity of the grand jury.
You have to determine whether it affected the integrity and ultimately whether it mattered. And, in terms of, did it probably influence the grand jury, the Mayfield standard, something else the court should consider about whether any of this matters. In March of 2024, Mr. Mello took another shot at a grand jury involving Mr. Kearney and Karen Reed for essentially...
But not this grand jury.
No, but...
All right, then we don't need to go there.
Your Honor, if I can have 10 seconds of leeway, none of the misconduct occurred in that grand jury. And what happened? The same allegations, same type of evidence, and that case was no build.
That's a whole different ball of wax. That's
the point
no.
Could it have influenced? We don't know.
I'm not going to guess about the grand jury presentment that I've never read, I've never seen, and involves a far different set of facts than this. All right? Whatever, I don't know the details of what happened or didn't happen between Mr. Kearney and Ms. Reed. I don't know and frankly don't care. Okay? What I care about is this grand jury. Okay? In much of that communication back and forth, allegedly with Reed, allegedly between him, it's not before me. I'm not going to draw an inference from that. I can't. You know that.
I'm not asking you to. It's the same video.
You just did kind of.
No, Judge, I'm not talking about anything other than it was the same video evidence and Tully talking about the same things. And admittedly,
I'm going to guess there was a whole lot more to that grand jury than these videos.
Not much.
Whatever. It's not what I'm not before
Understood.
Me. I'm not reviewing it. I don't have access to it, so I can't draw a conclusion as to whether or not it affects how it compares. So that's, believe me, the last place I want to go down the road is figure out any interaction between your client and Karen Reed. That's got no part of this trial. All right, not fair to anybody. Okay. All right. Anything else you want to tell me about this?
One other just response to something Mr. Cosgrove said, and when the court was asking him, why not just play or give the grand jury the opportunity, if they so choose, to have the videos, and the response was, well, they could have asked. I
didn't put a lot of stock in that, so I wouldn't spend any time on that.
Whatever they don't know, and the last point, Your Honor, is why rename the videos? Why say it comes from the intent? Why offer the opinions? It's to put their finger on the scale and to say, we believe he did it, you should believe he did it, and that's improper for a prosecutor to do as a legal advisor to a grand jury.
Fair enough. All right, I'll take it under advisement.
Two quick points.
Sure. Yep.
I just want to point out that from the Commonwealth perspective, the whole Scanlon argument is waived because they had the grand jury minutes at the time that they brought the last motion, including...
The Scanlon argument, it limited to the idea that they should have instructed.
Right.
Okay.
Right. The second point I want to make is the argument that they don't know what information came from Ms. Peters. I guess my response is, doesn't matter. It doesn't matter that she has an animus against Mr. Kearney, that the two of them are oil and water. Doesn't matter if the Commonwealth kept those videos from Jack the Ripper or whether the Commonwealth kept them from St. Teresa. The question is the video evidence authentic? And it is.
Okay. All right. Enough on that. Next issue. Do we have the third party here?
Yes, sir. Yes.
All right. From the defense, I didn't get a response or an opposition. Is there a response or opposition?
No opposition, Your Honor.
So you're fine with releasing these matters?
Judge, from our perspective, this is all out in the possession of the internet, if you will, and it seems like everybody has it and can look at it except Mr. Kearney, but that's another issue for another day.
Well, we returned it to him. Did we not? That was the order.
Yes, Your Honor, but it's, there's also,
Okay, whoever's on the video, you need to shut down.
I muted him, Judge. And further, Your Honor, Mr. Kearney provided Attorney Diller with all these communications.
So this is not an issue. Because my intent, frankly, my first impression here is I want to protect Mr. Kearney's rights not to have these materials, investigatory materials released. But if you're okay with it, I'm not going to stand in your way.
I appreciate that, and if you're inclined to do that, I certainly would ask you to do it.
Well, you didn't. That's why I asked you if you opposed it, and you said no. So,
but if that's your inclination, Your Honor, any layer of protection we appreciate. But unfortunately, you know, this is out on the internet. Number one, he's given it to Mr. Diller as a pro se, non-party deponent.
So what do you need it from Mr. Diller? Why do you need it from me if you already have it?
I don't know that I have it. I know that I just got a link from Mr. Kearney a couple days ago because I went into our case and also got a motion to compel, which was allowed. So I'm entitled to at least compare the two matters to see whether they are consistent and that it's comprehensive. I appreciate...
Why isn't this before Judge Gilday, not me?
It was before Judge Gilday, and he issued an order. There's a separate issue, which is we've executed a protective order, and any of the materials that will be provided from this case to us will be protected. There's also been a Gilday order that there's no dissemination or discussion of any of the confidential information, so there will be no leaks of data into the world, and this case will come to judgment prior to the O'Keefe case. So we'd ask that we get access to those materials. We know that they are the authentic materials, and we'll execute the protective order, as will the other parties who do not object in the O'Keefe matter. We'll all execute the same confidentiality protective order, and it'll be used exclusively in that case.
For the record, let's get your name, sir.
Attorney Mark Diller on behalf of the O'Keefe family.
Thank you. Okay. Anything further? Anybody want to be heard on this?
I don't have any objection to providing Mr. Diller with a copy of the same materials that I believe are already out there on the internet. Ironically, have been released not by Mr. Kearney personally, but through someone who was associated with him, as I understand it. The problem that I'm dealing with is
Judge Krupp's protective order.
Is essentially found on Exhibit B to the motion to intervene, which is the order from Judge Sisitsky, which was entered in the Karen Reed case. That motion was brought by Mr. Bradel on behalf of Mr. Kearney, and Mr. Bradel, as I recall, wished to bring it with respect to both the Karen Reed case and with respect to this case. Judge Sisitsky announced at the outset that he was only there to deal with the Karen Reed case. He wasn't going to touch the Kearney case, but language of the order prohibits all agents of the Commonwealth, which would seem to include me at the moment, Your Honor, requires us to maintain the confidentiality, which is now essentially non-existent, not share, publish, disseminate, or otherwise disclose the data or any information concerning the data. So I may be partially to blame for this matter being before Your Honor this morning, because my position was, I'm happy to give it to you, but I don't want to get caught between an order on the criminal side telling me that I have to protect this information, not release it, not disclose it, and an order on the civil side saying turn it over in response to the subpoena.
And this has already been produced by Mr. Kearney on his own?
That's my
correct,
understanding.
Yes,
Okay.
as a pro se, non-party deponent.
All right. I'll take it under advisement. Okay. Next motion. Paper 139. This was the issue of the items from the Taint team. Anybody want to be heard on this?
Yes, I'd like to be.
Okay. I'll hear you. I allowed it provisionally, but issued an order saying it couldn't be disseminated.
Right. The only thing I would say, Your Honor, is reading paper 134, which was the impounded report from Mr. Verino. It looks like some of the work has been completed, and there are 2 instances where he's looking for guidance from the court. That's the very last item, Apple iPhone A1549, and Apple iPhone on the next page, where he says the extraction attempt failed and he would need permission and in order to request an attempt by a law enforcement agency. I'm not sure how long it would take to accomplish those things. I haven't had an opportunity since, thanks to Your Honor's allowing my motion. I've only had this now for a couple of days. I haven't had an opportunity to check with somebody with more sophistication than I in matters of electronics and extraction. Someone more sophisticated than I would probably be any 12-year-old I could stop on the street, but I don't really understand what this would involve and how long it would take and what the expense would be. So I'd like a little time to look into that. But with respect to what's already been done, and it seems to be that they have, for example, the next to last entry, Honorable Macy reviewed and marked item for privilege, working on producing the potential privilege data with notations by Honorable Macy, which items are deemed privileged for defense production. This was dated March 25th of 2026. This Taint team process has been very laborious, and I would really like to get the ball rolling on this, or rolling a little further before we are up against the trial date.
How soon do you think, how long will it take you to formulate your position on further steps?
I don't think it will take me long at all, Your Honor. A week?
A week. Mr. Bredel, you want to be heard on any of this?
Judge, I don't object to a week, if counsel wants to.
You have the materials he has, he's released to you.
Yes.
The report.
Yes.
Okay. So.
Oh, see, I wasn't even aware of that.
Well, that was the order that I issued.
Oh, you mean this? But, okay.
That was the order that I got, was to release that report.
Right. But the text of the report says that they have the data, Macy's reviewed it or has reviewed some of it. I would like some indication to the Taint team that we'd like to get it.
I don't know what exactly is in play here. Mr. Brett.
Yes, Judge.
You work with Mr. Cosgrove.
Okay, that's.
You guys need to file a further motion to assist this process to speed it up. Just get it to me.
We would like
I'll
to
draft
receive it first.
something to Mr. Bredel and.
Yeah, you guys can work.
We'd like to receive it first, though, Your Honor. I appreciate Commonwealth referenced this in their submission, that to the extent that there is a privileged notations in here, we'd like to see it first, evaluate it.
Understood. I get that part.
Okay.
All right. So look, get a report back to me 2 weeks from today. All right. And if you need a further court order to move the ball forward, I'd be glad to do that. All right. I assume you guys will come up with some agreement on it, right?
Yeah, I think it'll be a good.
Yes, Judge. I proposed to counsel that I'd just like to have it for let's say a week prior to the.
I'll give you 2 weeks to sort this out.
All right. Appreciate it.
I suspect you don't need me to interfere with this.
I don't think so, Your Honor.
Yeah. My understanding may be less than a 12-year-old. Okay. Last issue, which is the issue for disclosure on Proctor. Did you folks have some discussion about this?
Yes. We did, Your Honor. We're almost there.
All right.
I think we need court guidance on one disparity.
It's very wide right now, far too wide. All right. I think I know where you can go. I'm not sure
we're not going to make you go through the labor of looking at our stuff.
All right. Tell you what, 2 weeks to give me a report on where you stand on that. All right. If you guys can reach an agreement, we will. All right. We're going to close the Zoom now. That's it. The Zoom is shut down.
Goodbye.
If I may, Judge, the only issue we're disparate on is the scope of the protective order relative to what Mr. Kearney can be shown and not shown. And we were proposing that it be just case case-related materials from Proctor extraction, we'd be entitled to show him, not provide copies, to show him case-related materials. And I think counsel has a little more of a specific issue. That's the only issue we're disparate on.
If you guys have an agreement, and you want to work it out, that's fantastic. If you still need more time to have this discussion, you want to come see me by Zoom, you can do that. If you guys have, again, if you guys reach an agreement, I'm not going to stand in the way. If you need further clarification after discussion, okay, tell me.
I was just hoping to gently push the Commonwealth today to put their position out, which we discussed prior to this hearing, and perhaps Your Honor can make the ruling. I think it's a pretty straightforward thing.
Tell me what you think I should know, Mr. President.
Essentially, I have folded my tent, so to speak, that I've agreed to provide information to Mr. Bradle to the same degree that has been provided in the cases where there is Proctor discovered. And Mr. Bradle has agreed that essentially the same protective order will be issued, which essentially boils down to the materials provided will be provided only for the use of counsel and may be shown to the client, but the client may not receive copies of those materials.
Is there any restriction on the use of those materials by the client? I think that's probably what we're
Yes.
circling around here.
Yes. That's my concern, and it seems to me that to the extent that the information, there's really two potential pieces of information. One is case-specific information, anything Mr. Proctor may have said relating to the specific case and Mr. Kearney.
That's would almost be on that.
Sure. I would have no problem with that being shown to Mr. Kearney. However, it seems to me the biased information which is, as I understand it, a pretty standard. It's really the same for all defendants. The stuff going back, whatever the comments that Mr. Proctor made about this person or that person that potentially could be used to impeach him if he is called as a witness and show bias that have nothing to do with Mr. Kearney in particular.
That's a pretty good question.
I don't wish to be shown. I would like to be restricted from showing to Mr. Kearney because I don't think that counsel needs his input if we come to trial to present a statement that Mr. Proctor made 12 years ago about some woman or minority or whatever. And if the likelihood is it's only going to leak out into the internet to the extent that that's already possible embarrassment.
Can you start referencing people make silly comments, inappropriate comments, unacceptable comments? It's going to open up things that we just don't necessarily need to come down. Those across that bridge when we get to the logistical argument. Mr. Bradle, so what do you think
This issue that the Commonwealth wants to sort of parse out is too vague to parse that out. I can't look at something and say,
I'll give you 2 weeks.
it makes it adverse to the client, Your Honor.
I'll give you 2 weeks to confirm. If you guys haven't come to an agreement by the next, call Mr. Zonley.
Okay.
Come in and see me. It's a 15-minute hearing. It should not take us long.
Thank you.
All right, so we've got 2 weeks on the issue of the Taint team issue, and 2 weeks on this issue too.
Thank you, Your Honor. And then there's also a housekeeping issue relative to the dates, Your Honor, for trial. Motions on May. I think we wanted to propose to the court. I think we hammered this out before it came out, which is that we wanted to propose Friday, December 4th for motions in Monday, Monday, December 7th, for trial under.
So, I have another concern here, and I don't know that we need to resolve it today, but, I want to put it on what's radar, which is, this is an Norfolk County case. Where is this trial?
Well, I'm here right now. Let's put it this way. Wherever it happens, we go for county juries. Okay? That should satisfy any constitutional concerns.
I think that logistically, Plymouth Superior Court would be an excellent location.
Logistics, very evidence, is going to be a discussion which we're going to have with other folks who are involved here.
I appreciate that, I just wanted to put it up.
Is it fair to say, Judge, that you'll know maybe in September when the next rotation comes through?
We'll have a, well, I'm in this room till the end of December.
Oh, okay.
So I'm assigned to Suffolk County
You're
until January of 2027. So the assumption is going to be with me, and the assumption is going to be in this room. But we're going to have to make arrangements because this is a Norfolk County case. It's entitled to Norfolk County jurors unless we wait. And that would be my intention. Wherever this happens,
I'm going to discuss that with Mr. Conley,
that it be tried in front of the Norfolk County jurors.
whether we wait.
Well, I guess I can word on that as well. So,
I had one other issue to raise with Mr. Bradle. I don't need to ambush him, but I do want to bring it to the attention of the court. It has been, so far as I recall, and I don't think I've lost my memory to this extent yet, no motion to suppress with respect to the devices that were seized from Mr. Kearney pursuant to warrant. Some of them may not be visible, but we have at least the two cell phones which the search was conducted, and the fruits of that have been turned over to the defense. Defense of the motions. I don't want to get to a week before the day of the trial and know that Your Honor needs to hear a motion to suppress.
the right to cell phones you intend to use.
Well, yes.
Folks need to have a discussion about this.
Well, I'm sure we will have a discussion about it in Mislabeled. I'm just concerned about,
It may be an intimidate issue, Judge. We don't see any suppression issue.
All right, so there's no motion to suppress it. We'll deal with it as a motion to eliminate.
That's where we were going.
All right.
that's fine.
Here's what I suggest, folks. Someone, like the judiciary tells me I'm going to get a lot of motions to eliminate. So maybe we should go back another week on the motions. Or at least take it to November the 30th, which is the Monday before we'll bring in the afternoon and deal with that. That gives us a full week to get decisions out and adjustments to the trial strategy.
Judge, can we go? Can I just confer 1 second?
If Your Honor would like to avoid the Thanksgiving week, we're wondering if we could move it back to, say, the 19th or 20th of November for motions to eliminate.
Does that mean?
That's a Thursday and Friday. The 18th of November.
We were at the list on Mondays and Wednesdays, so to the extent we can stick with that.
18th, one of that, okay? Yes, that's fine.
So, any other schedule issues?
Can we maybe file those, so agree to file them like a week prior?
Couple days on it.
So 11, out of court filing, November 11th.
Fine by me. Okay, just one other matter.
That's Veterans Day. 10, whatever the closest date to that.
Close the what? Give me another day.
10. 12.
Oh, sorry, 12. Okay, although the Zoom is now shut down, let me just send this message right now. The court is fine with Zoom. The court is perfectly happy to have the public observe and see the proceedings that are here today and going forward to observe the electronically observe the proceedings. What the court is not going to tolerate is commentary over the court's audio about people's thoughts. Happened 3 times. 3 times is all I need. I'm going to reopen the Zoom for the next hearing. If it happens just once, I'm going to shut the Zoom off, and that will be it for Zoom going forward. This is not a participatory experience for anyone but the parties. The message I'm sure will get out to the various parties who would like to listen and be broadcast. Zoom is a privilege, not a right. You don't get to participate in the hearings. Okay, anything else we do today?
Just a little bit of clarification, Judge, on the dates. So I want to see if I have this right. November 12th, out of court, motion to eliminate service. November 18th, motion to eliminate, and that's 2 p.m., Mr. Clerk? 2 p.m. And then December 4th, is that still a date, or are we off? December 7th, trial.
December 7th. All the folks will be flexible. If you need to come back a second time, come back a second. I'll make time for you, but it needs to make time.
Thank you.
Okay?
And we may come back on the Proctor executive order in the next couple.
So the 2 outstanding matters, number 1, motion dismissed to decide. The other 2 issues, on Taint and on the Proctor discovery, if you need further guidance from the court, let me know. Give me 2 weeks to try to sort it out. If you need me to decide, I'll decide. Anything else? Consider on the spread.
Very good. Thank you.
All right, thank you very much for your arguments today.
Manager under advisement, the court set the following future court dates: November 18th, final pre-trial hearing at 2 p.m. with a trial, or 2 weeks later on December 7th at 9 a.m. All rise.